Hello everyone. Am I audible? Am I audible to all of you? Yes. Okay. So we have reached to our last class. Thank you, Ananya. We have reached to our last class of SOGA, and today we are going to discuss about unpaid seller. Unpaid seller. So have you revised the earlier classes of SOGA? If anybody is having any question, they can ask. Okay. So let's move to unpaid seller. Uh, what do you understand by the term unpaid seller? से इफ आई से दैट कि आपने एक शॉपकीपर के पास कुछ सामान खरीदा है से 1 kg ऑफ राइस एंड अमाउंटिंग टू ₹100 and you have already paid ₹80 and 20 rupees is remaining. Do you think he will be called as unpaid seller?
Yes, ma'am.
Okay. And if suppose if you have given a check of ₹100 and it has been dishonored, then also he will be called as unpaid seller.
Yes, ma'am.
Okay, so the definition is also similar to definition is also saying the same thing. The seller of goods is deemed to be an unpaid seller within the meaning of this act when the whole of the price has not been paid off. Okay, so it means even a small amount is pending, then also he will be called as unpaid seller. It is not necessary that the entire amount has to be pending, then only the person will be called as unpaid. Okay. Second is when a bill of exchange or other negotiable instrument has been received as conditional payment and the condition on which it was received has not been fulfilled by reason of the dishonor of the instrument or otherwise. The example which I have provided is one that. Okay. And the second point is in this chapter, the term seller includes any person who is in position of a seller, as for instance, an agent of the seller to whom the bill of lading has been endorsed, or a consignor or agent who has himself paid or is directly responsible for the price. So one day we have given an example that one person is having some stock who is representing the seller, and he has right to collect the payment also. So if that person to him, if you have received any goods from him and you have not paid the price, then that person is also called as unpaid seller. Section 46, unpaid sellers sites. Okay. Subsection 1. Subject to the provision of this act and of any law for the time being in force, notwithstanding that the property in the goods may have passed to the buyer, the unpaid seller of goods, as such, has by implication of law a lien on the goods for the price while he is in possession of them. Okay. What do you mean by notwithstanding that the property in the goods may have passed to the buyer? Because what we are trying to understand from here, that unpaid seller, uh, the unpaid seller of the good has what right, a lien on the good for the price while he is in possession of them, right? So we are seeing that unpaid seller has a right that if he has not received the payment, then he can have a right of lien, and in case of insolvency of a buyer, a right of stopping the good in transit after he has parted with the possession of them. And the third is right of resale. So what we are understanding from this is that there is three right which unpaid seller has. One is your lien on the good, second is stopping the good in transit, and third is right of resale. Okay. Why it is mentioned that notwithstanding that the property in the goods may have passed to the buyer? What do you mean by property?
Ma'am, it means the seller has the right even if the goods are being delivered already to the buyer.
No, no, but we are talking about the lien right now. Right now, we are discussing lien, and even if in the case of lien or in the stopping the goods in transit, in both of these cases, the goods is not delivered to the buyer, right?
Yes, ma'am.
So, what exactly this mean? Notwithstanding that the property in the goods may have passed to the buyer. At least literal meaning of this, what it trying to say. Just by reading this, no, no, this statement as a layman, what you are trying to, what you are understanding from it. Unless the goods have reached the buyer. No, no, no. Ananya, what do you mean by the property? Then we have already discussed, na, the definition of property in the good. Can anybody tell me what is here the property means? Okay, can anybody tell me what do you mean by contract of sale? Contract of sale may be absolute or conditional, or it has to be absolute. What do you understand by absolute or conditional? Please don't tell me that you don't know the answer. Okay, as Sahu, you have mentioned it has to be absolute. Okay.
No, ma'am, it's maybe absolute or conditional.
Yes, Kisan, it may be absolute or conditional. So when I am saying absolute, what it exactly it means? Anybody? You can see the definition of contract of sale if you want to. एब्सोल्यूट का मतलब इमीडिएटली आपका प्रॉपर्टी ट्रांसफर हो चुका है, राइट? एंड कंडीशनल का मतलब व्हाट व्हाट हैपन इन केस ऑफ एग्रीमेंट टू सेल? Agreement to sell is an absolute one or it is a conditional? Ananya, yes, Ananya, correct. It is conditional because there is a condition that upon certain time, elapse of certain time, or upon fulfillment of certain condition, then the sale will happen, right? When when the time elapsed, then it will be absolute sale, or on fulfillment of the condition attached. If it is fulfilled that if the seller fulfilled that condition, then it is converted to sale, right? So uh, notwithstanding that the property in the goods. So property means here general property only. We are discussing the property, right? General property, special property, we have discussed. So in case of sale, what happened? General property transferred, right? So whether the general property in the good may have passed to the buyer. So is it possible that the property is with the seller, but um, still the buyer has to make the payment? Is it possible? We have already read it, that if the seller and buyer, if there is an agreement between the seller and buyer that the price has to be paid, and if it has not been paid, then then also and the price might be paid first, and the property might be transferred later on. There might be a situation, right? So in this case, even if the price has to be paid first and the property has to be transferred later on, then also when the price is not paid, then he becomes an unpaid seller. Okay, so that's why it is written that notwithstanding that the property in the goods may have passed to the buyer or not. Okay, the unpaid seller has three rights: a lien on the good for the price while he is in possession of them. If he is not in the possession of them, then whether he is able to exercise lien, obviously not.
No, ma'am.
Yes, in case of insolvency of the buyer, a right of stopping the goods in transit after he has parted with the possession of them. So uh, when the right of stopping the goods in transit is there, it is only in case of insolvency of the buyer. So if the buyer is not insolvent, then the seller has no right of no right of stopping the goods in transit. And what do you mean by goods in transit? That means he has parted with the possession of them, and it has not been delivered to the buyer. Okay, so the goods is neither with the seller nor with the buyer. It is in transit, and the seller has the right to stop the goods in transit only when the buyer is insolvent. If the buyer is not insolvent, then he has no right to stop the goods in the transit. And the third right is right of resale. Okay, where the property in goods has not passed to the buyer, the unpaid seller has, in addition to his other remedies, a right of withholding delivery, similar to and coextensive with his right of lien. So uh, there is two scenario: when the property has been transferred and when the property has not been transferred. When the property has been transferred, then he has three rights, but when property has not been transferred, then he has four right. Apart from these three, he has also a right of withholding delivery, and right of withholding delivery is similar to and coextensive with his right of lien. It is very similar, matlab, like you are not delivering the good to the person, to the buyer, right? Okay, we'll discuss in detail unpaid seller's lien. Seller's liens, section 47. Subject to the provisions of this act, the unpaid seller of goods who is in possession of them is entitled to retain possession of them until payment or tender of the price in the following cases. So, in what scenarios he can retain the possession? These are the three scenarios in which seller has right to lien. Okay, when the goods has been sold without any stipulation as to credit, मतलब उधार में हमने आपको नहीं दिया है, तो उस केस में आपको immediately पेमेंट करना है बायर को. अगर बायर is not making the payment, then seller has right to lien. Okay, where the goods have been sold on credit, but the term of the credit has expired. Okay, so in this case, suppose the credit duration is 15 days and the goods is also in the possession of the seller. If during the if during that 15 days he has not made the payment, or on 15th days also he has not made the payment, then on 16th day he has right to lien if that good is with him. Okay, where the buyer becomes insolvent. That's obvious. Second point, the seller may exercise his right of lien notwithstanding that he is in possession of the goods as agent or belly for the buyer. Okay, so it's not necessary. Suppose that I have given you one example wherein in case of constructive delivery, what happened, that the seller is having one warehouse wherein he was holding that goods for his own, for no, for his own purpose, like he was the owner of that good, and that warehouse is his only, and it was he has recruited one caretaker. Now he has sold that good to somebody else, say Mr. B. Now Mr. B has inspected the good and bought the good, but he has not taken the delivery, but he has given the constructive delivery, right? That the caretaker is now holding the goods on behalf of Mr. B, right? So in that means what is prima facie happening, that seller is the agent of buyer, then in that case he is holding that good, or he is a belly for the buyer, that during that period, right? So even if the constructive delivery is already happened, and the good is in the position, physical position is with the seller, and he is acting as an agent or a belly for the buyer, that time also, if the payment has not made, then also seller can exercise the right of lien. Okay. Section 48, part delivery. When an unpaid seller has made part delivery of the goods, he may exercise his right of lien on the remainder unless such part delivery has been made under such circumstances as to show an agreement to waive the lien. Okay. What do you mean by unless such part delivery has been made under such circumstances as to show an agreement to waive the lien? ट्राई कीजिए, क्या समझ आ रहा है आपको इसमें? Literal meaning, what you are understanding from that? So you have to try it. There is a contract made in contrary to this provision. To the right of lien, you are saying, Ananya. See, if the part delivery, if they are through an agreement, if they are saying that if the part delivery amounts to waiver of the lien, that means if and the part delivery has been made, that means that seller has waived the right of lien. Okay. This is what it is saying. Unless a part delivery has been made under such circumstances as to show an agreement to waive the lien. Section 49, termination of lien. The unpaid seller of goods loses his lien thereon when he delivers the good to a courier or other belly for the purpose of transmission to the buyer without reserving the right of disposal of the good. Okay. Without reserving the right of disposal of the good. What do you mean by that? Is there an possibility wherein the seller has right of disposal but property has been transferred, or when the property has been transferred but the right of disposal, if the property has been transferred, then the right of disposal is not with the seller? I'm asking that the property has been transferred to the buyer, but is it possible to keep the right of disposal with the seller when the property has already been transferred to the buyer? Can right be separated? S Sahu is saying no. Anybody else think the definition which we have discussed at the time of no general property versus special property? Uh, have you seen any of such scenario wherein the right of possession is with somebody, but the right of ownership is with somebody else? Or when the person is having the right of ownership, that means he cannot give the possession to somebody else. Yes, Kishan, you are trying to say.
Ma'am, it's happened in a higher purchase where the ownership is at the financer and the possession is with the buyer.
Okay, first of all, hire purchase. You just remove this word hire purchase. What you are trying to say is ownership is okay. That is also fine. Ownership is with the.
Ownership is the financer and the buyer has the only the possession of the good
Mhm. That ownership is.
until the payment of last payment.
No, 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 no. You are saying the
Ma'am,
ownership.
I'm wrong. I'm not sure about that. I'm wrong. I know, but it's sorry, ma'am.
See, if in nearby, or if you have, if any of you have purchased uh, any vehicle, automobile, this is what you are trying to give example, right? So in that case, the ownership is with whom? Is with the financer, or is it with you?
With the financer, ma'am.
Think. Have you read TPA, Transfer of Property Act? That would be more easier for you to understand. आप लोगों ने टीपीए पढ़ लिया है क्या? मॉर्गेज पढ़ा है? कोई तो बताओ. आप लोग हाँ ना, मतलब नॉट रेड और पढ़ लिया है और डोंट रिमेम्बर. देयर माइट बी थ्री सिनेरियोज,
Yes,
राइट?
ma'am. I don't remember properly the types of mortgages. I know what you're trying to say, but I can't
See,
remember.
even if we are wrong, okay, we are discussing here, even if you are wrong, or if whatever be it is, just try to give answer, otherwise you will not have. The whole agenda is like we have to start thinking, and sometime even if no, you try to uh, like at least apply your brain. It might be wrong, it might be right. Nothing is going to happen bad, right? For it, if you try. Okay, so in this case, what I'm trying to say that ki when you buy a car or any kind of vehicle, so in that case what happened, you are buying in your name, and then you are putting a charge over it, and when it is financed, correct?
Yes, ma'am.
So ownership is with you, otherwise it's the financial should have the RC number.
Yes, ma'am.
Yeah, so the ownership is you, with you only. So in that case you are the owner. In that if that is the scenario, it is not in hire purchase thing. Hire purchase के केस में क्या होता है कि हाँ, the ownership is transferred only upon the payment of last installment. But it's not necessary कि in every finance, whenever you are taking loan on certain thing, that means it is a hire purchase. That is not the case. You the moment the ownership is transferred to you, and you have put it on if the encumbrance is made over it and you have taken loan over that, that means you have put that uh, as you have mortgaged that thing, like in the title deed. What happened, right? Like with the bank, when you buy a property, suppose, then you just the ownership is with you, the title deed is in your name, but you just put that title on that title deed. You are taking the loan from the bank, and when you make the payment, then you just take the title deed from the bank, but the
Yes,
ownership
I'm
remains
getting.
with you. Yes, but when you don't make the payment, then the bank sell that property, and then recover that amount. That's how it auctioned, right? So in this case, what we are discussing, without the reserving the right of disposal of the goods. Okay, so we are discussing about that. Is it possible to separate certain rights from the bundle of right? So we have discussed that there is a possibility that possession is with somebody else, ownership is with the somebody else. Correct. Similarly, even and possession is also one of the right from the general, one of the right out of all the rights. What all rights are with the owner? In case of ownership, what all rights the owner has? Possession, disposal, destruction, use, right? So even when you are giving possession of property to somebody else, that means you are yes, Ananya, correct. So when you are giving possession to somebody else, obviously you are segregating one right out of all the right. You are giving one right to somebody else, but still the general property is with you. Similarly, the right the buyer, there is through the terms of contract, right of disposal may remain with the seller, and ownership may remain with the buyer. That is also possible. Okay, so in this case, what it is saying, that when he delivers the goods to a courier or other bailee for the purpose of transmission to the buyer, without reserving the right of disposal of the goods. So if the seller has no right, right of disposal, then in that case he will not able to exercise no lien. But if he has reserved the right of disposal, then in that case the lien is still with, he can exercise the lien with him. See, when the stoppage in transit happened, then what happened, he re-delivered the good to the seller, and when the seller is in the possession of the good, he can exercise right of lien, right? So this is what it is trying to say, that ki once if the seller is not reserving the right of disposal, then he loses the right of lien also, when the buyer or his agent lawfully obtains possession of the goods. Okay, so for exercising the right of lien, uh, the very much important is that seller should have the possession. If the seller is not having the possession, then he will not able to exercise it. So if already the buyer or his agent has lawfully obtains the possession, then seller right to lien is terminated by waiver. So he himself has waived the right of lien, then also unpaid seller loses his lien, right of lien. The unpaid seller of goods having a lien thereon does not lose his lien by reason only that he has obtained a decree for the price of goods. So if he has right to no if he has obtained the decree for the price of good, then in that case that doesn't mean that he has lost the right to no right of lien. He still has that right. Right to recover price is another right, and right to lien is another right. Okay, don't confuse with that. Okay, stoppage in transit. Subject to the provisions of this act, when the buyers of goods become insolvent, the unpaid seller who has parted with the possession of the goods has the right of stopping them in transit. That is to say, he may resume possession of the good as long as they are in the course of transit, and may retain them until payment or tender of the price. Just we have discussed that if the goods is in transit and if the buyer becomes insolvent, then the seller has right to stop the goods in transit. And once he stopped the goods in transit, he has right no what he may resume the possession of good and retain them until the payment or tender of the price. When he is retaining them, that is right of lien. Okay. Section 51, duration of transit. Goods are deemed to be in course of transit from the time when they are delivered to a courier or other bailee for the purpose of transmission to the buyer, until the buyer or his agent in that behalf takes delivery of them from such courier or the other bailee. ये सिंपल है कि आप बायर ने डिलीवरी नहीं लिया है और सेलर ने आपका पोजीशन पार्टेड कर लिया है, और उस ड्यूरेशन के बीच में जितना जो भी टाइम है, उस ड्यूरेशन उस टाइम पीरियड को आप वो ड्यूरेशन जो है आपका वो ट्रांजिट ड्यूरेशन है. जब एजेंट या बायर आपका डिलीवरी ले लेता है, तो ऑब्वियसली seller has no right to stop that good because it is not in transit. If the buyer or agent in that behalf obtains delivery of the goods before their arrival at the appointed destination, the transit at an end. Okay, so what it tells that suppose the goods has to be no transport the good has to be delivered to Bhubaneswar. It traveled from Kyonjhar, and the good has to be delivered to Bhubaneswar location. But what happened, the buyer has taken the delivery in the Cuttack itself. Then the moment the buyer has taken the delivery, even before the destination point, the moment the goods the position of goods transferred from sellers to buyer, that time uh, your transit comes to an end. Okay. Third, if after the arrival of the goods at the appointed destination, the courier or the other belly acknowledges to the buyer or his agent that he holds the goods on his behalf. Okay, this is very much important, that even if it is with the belly or the carrier, but if he has after reaching to the destination point, that delivery person has called the buyer and he has acknowledged that he is holding goods on his behalf. If he is not saying that on his behalf is not holding, that then this section will not apply. Okay, if he has already informed that he is holding the goods on his behalf, and the buyer has might have told him, okay, he has given another destination point, then still the delivery, it will amount to the as equivalent to the delivery only. Okay, and the transit comes to an end and continues in possession of them as belly for the buyer or his agent, because he has acknowledged that he is holding on his behalf. Then uh, uh, the transit is at end, and it is immaterial that the further destination for the goods may have been indicated by the buyer. And why it is mentioned that belly for the buyer or his agent? Can anybody tell me? When he acknowledged that he is holding the goods on his behalf, then the position of the courier is changed as belly for the buyer or his agent. I hope it is clear, because earlier he is holding on whose behalf? On seller's behalf. Now the moment he has informed him that he reached to a destination and he is holding on his behalf, then his position changed. If the goods are rejected by the buyer and the courier or other belly continue in possession of them, the transit is not deemed to an end, even if the seller has refused to receive them back. Is it clear? See, if that good is not been delivered to the buyer because buyer has rejected that good, okay, and even if the seller has refused them, if the person who is holding that good is on whose behalf? Is it on behalf of buyer or it is on behalf of seller? Tell me. Do you think the transit is come to an end? Because you need to see that goods are rejected by the buyer. He has not confirmed that he's taking the delivery, or he has informed any other location. So he's still holding that no the driver of that vehicle is still holding that on behalf of seller itself. So that's why the goods are still called as stop no in transit, and the transit is not come to an end. Okay. When goods are delivered to a ship chartered by the buyer, it is in question, depending on the circumstances of the particular case, whether they are in possession of the master as a courier or agent of the buyer. What it is trying to say? that suppose this ship is chartered by the buyer, but whoever is no, that master of that ship is holding on whose behalf, that is very much important. If it is holding on behalf of, can anybody try to try what it is trying to say, Kishan? See, if the master of the ship is holding on behalf of the buyer, then in that case it will amount as delivery itself. Okay, but if it is not holding as on behalf of the buyer, then it is still considered as in transit. Okay, you need to understand on whose behalf he is holding the good. It is as simple as this. If he wrongfully refuses to deliver the goods to the buyer or his agent, in that behalf the transit is deemed to be an end. Okay, where a part delivery of the good has been made to the buyer or his agent, in that behalf the remainder of the goods may be stopped in transit unless such part delivery has been given in such circumstances as to show an agreement to give up possession of the whole of the goods. This also we have discussed, that if the part delivery amounts to no uh, showing that an agreement to give, if the part delivery amounts to of giving up the possession of the whole goods, then even if the part delivery is made, then it will considered at that as equivalent to that the seller is not having the possession of that good, even if he is having the remainder good with him. Any question? Okay, how stoppage in transit is affected? Before discussing this, can anybody able to differentiate between right of lien and right of stoppage in transit? What are the differences in between them? राइट ऑफ लियन और राइट ऑफ स्टॉपेज टू स्टॉपेज ऑफ ट्रांजिट के बीच में क्या डिफरेंसेस आएगा? Yes, Kisan. Please switch on the mic and tell.
Ma'am, in right of stoppage in transit, there are the only right that only case if the buyer is insolvent, and in the case of right to lien, sorry, no, can't.
हाँ हाँ, मतलब आप बोलना चाह रहे हैं कि राइट ऑफ लियन के केस में आपका इवन व्हेन बायर नॉट इंसॉल्वेंट देन आल्सो राइट ऑफ लियन कैन बी एक्सरसाइज्ड, राइट?
Yes,
So
yes,
that,
yes, ma'am,
हाँ,
yes, ma'am, yes, ma'am.
so that means that we have understood whether the buyer is insolvent or not. In both the scenarios, right of lien is there.
Yes, ma'am.
Okay, but stoppage in transit, right of stoppage in transit is only available with the seller only when the buyer
In
becomes
the buyer
insolvent.
is insolvent, right?
Yes, otherwise not. Okay, it is very very important. And what is the essence of this right? Right of lien has right to retain. No, uh, because the position is already with the seller. So what he is doing, he is retaining that position, right?
Right, ma'am.
But in the in case of stoppage in transit, what is happening? He's regaining his positionary right, because what happened in case of when it is in transit, when the goods parted away from the seller. So it means that when the seller is applying the stoppage in transit, means he's regaining the right of possession, right of lien. He's no taking redelivery of that, like he's taking back that good. He's asking that courier to stop that good to be delivered to the buyer, and he's asking back the good, right? So he's regaining that good. That is the essence. And obviously the seller should be in possession of that good for exercising right of lien. But do you think in that case, in stoppage in transit, the seller should have the possession? Obviously not. The seller should have parted with the possession, correct?
Yes, ma'am.
But one thing we have just discussed, that he has parted with the possession, and that possession is with whom? Obviously not with the buyer. And that possession is with no with the courier or with any other bailee. And he must have right of disposal. If the right of disposal has been transferred, then right of lien go away. I hope it is clear, or you have confused by this statement. When stoppage in transit not possible, when the stoppage in transit is only possible when it is in the possession, right? In possession of whom? With with not with the buyer.
With the career, right?
And the courier should have the right of disposal. If he's holding on behalf of buyer, then in that case also seller lose the right to lien, right to stoppage in transit, that we have discussed. When right of stoppage in transit, the seller is not able to apply. So on whose behalf the courier or belly other belly is holding that good, that has to be seen. Okay, how stoppage in transit is affected? So the unpaid seller may exercise his right of stoppage in transit either by taking actual possession of the goods, or by giving notice of his claim to the courier or other bailee in whose possession the goods are. ओके, सो ही में इधर से दैट कि आप जो है उसको रीडिलीवर कर दो मेरे, मतलब आप जो है उसके वो जो गुड्स है मेरे पास वापस ले आओ, और या फिर वो नोटिस दे देगा कि आप उसको डिलीवरी नहीं करना है बायर को, राइट? दिस इज व्हाट इट इज ट्राइंग टू से. सच नोटिस मे बी गिवन ईदर टू द पर्सन इन एक्चुअल पोजीशन ऑफ द गुड्स और टू हिज प्रिंसिपल. मतलब जो भी ड्राइवर है उस व्हीकल का, उसको या तो आप बोल देते हैं कॉल करके कि आप जो है उसको डिलीवर नहीं करना है बायर को, या फिर उस व्हीकल का जो ओनर है, जो प्रिंसिपल है, उसको आप इन्फॉर्म कर देते हैं कि आपको ये डिलीवरी नहीं करवाना है बायर को, राइट? इन द लेटर केस क्या होता है कि ये जो आप प्रिंसिपल को अगर इन्फॉर्म कर रहे हैं, तो उस केस में नोटिस जो देना है आपको, वो एक ऐसे टाइम पे देना है या फिर ऐसे सर्कमस्टांसेस में देना है, ताकि प्रिंसिपल के पास एक रीजनेबल टाइम होगा कि वो कम्युनिकेट कर सके सर्वेंट और एजेंट को, जो उसके पोजीशन में है गुड्स के, राइट? टू प्रिवेंट अ डिलीवरी टू द बायर. अगर आप ऐसे टाइम पे इन्फॉर्म कर रहे हैं जहां पे आप वो इसको इन्फॉर्म ही नहीं कर पाएगा, तब भी मुश्किल है, राइट? So that information should, in order to reach that information to the servant or agent, so that he should prevent the delivery to the buyer. This has to be seen. It जनरल बैलेंस में आप एकदम बेसिक है, कॉमन सेंस में भी हम समझ पा रहे हैं कि ये क्या बोलना चाह रहा है, करेक्ट? When notice of stoppage in transit is given by the seller to the courier or other bailee in possession of the good, he shall redeliver the goods to or according to the direction of the seller. See, it is not necessary. We have already discussed what through stoppage in transit, what right he is doing, right to regain. But it is not necessary the seller will ask that entire आप मेरे को वापस ला के दो. He might say that कि आप किसी और फलाना फलाना इंसान को दे दो. right? That is also possible. That is what it is trying to say, that he shall redeliver the goods to or according to the direction of the seller. The expense of such redelivery shall be borne by the seller. Okay. Transfer by buyer and seller. Effect of subsale or pledge by buyer. Subject to the provisions of this act, the unpaid seller's right of lien or stoppage in transit is not affected by any sale or other disposition of the goods which the buyer may have made, unless the seller has assented thereto. अच्छा, यहाँ पे not affected by any seller, sale or other disposition. What it means? इसका मतलब यही बोलना चाह रहा है ना कि बायर ने जो है वो गुड्स को किसी और को सेल कर दिया है, या फिर कोई अदर डिस्पोजिशन, मतलब मोर्टगेज कर दिया है, प्लेस कर दिया है, कुछ भी कर दिया हो उस गुड्स के साथ में, राइट? कोई चार्ज लगाया हो उस पे, राइट? तो इन दैट, इवन इफ दैट इज डन, देन आल्सो द सेलर, अगर सेलर ने उस मतलब फर्दर सेल के पे या फिर कोई अदर डिस्पोजिशन पे एसेंट नहीं दिया है, इन दैट केस द अनपेड सेलर हैज right of lien or stoppage in transit, still has right of lien or stoppage in transit. But if the seller has assented to this no, sale or other disposition, then the unpaid seller lose the right of lien or stoppage in transit. I hope it is clear. Shall I go ahead? Okay. Provided that where a document of title to goods has been issued or lawfully transferred to any person as buyer or owner of the goods, and that the person transfers the document to a person who takes the document in good faith and for consideration, then if such last mentioned transfer was by way of a sale, the unpaid seller right of lien or stoppage in transit is defeated. And if such last mentioned transfer was by way of pledge or other disposition for value, the unpaid seller right of lien or stoppage in transit can only be exercised subject to the right of the transferee. What is it is trying to say? It is basically trying to say about see that the keyword is your good faith and for consideration. So if the buyer, no, suppose Mr. A has sold certain good to B, and say your iPhone, okay, and A has sold iPhone to B, and that iPhone is in position of A only, and B has not made the price, not paid the price, and B has sold that good to C, and C has paid the amount uh, to B, and he has taken that, and the and B has no transferred the document. He has transferred the ownership document of title to C. Okay, and C has also paid the amount in good faith. In that case, this sale is in that case the right of lien or stoppage in transit is defeated. I mean, that will not remain with the A will not able to exercise that right. Okay, or if he has but if B has given it as a gift to C, that time the seller has still the right of lien or stoppage in transit. Okay, and if he has no given it on pledge, say he has taken certain some amount of loan from C, and he has put that good as a pledge to C, that means uh, C right will be first, then the right of the seller, because he has taken in good faith. He has done that place in good faith. I hope it is clear. Any question? Okay. Where the transfer is by way of pledge, the unpaid seller may require the pledgee to have the amount secured by the pledge satisfied in the first instance as far as possible out of any other goods or securities of the buyer in the hands of the pledgee and available against the buyer. तो से अगर सी के पास में आईफोन के साथ साथ और भी बहुत सारे गुड्स उसके पास प्लेज में है, ओके, से you can keep it any good with him, so he might ask that कि आप जो है पहले वो goods को आप बेच आप you know you आप बेच दीजिए and then recover your debt amount. So the seller might say that, unpaid seller might say that, and then in that case, that iPhone, the right over the right to sell, that iPhone will come last, but and all other goods or any other assets which the pledgee is having, that he will first use that asset or goods to set off the debt amount, and if it is satisfied, then he will not sell he will not exercise the right over that goods which is with the unpaid seller. I hope it is clear. Section 54, sale not generally rescinded by lien or stoppage in transit. Okay, so it is talking about your right of resale. Subject to the provision of this section, a contract of sale is not rescinded by mere exercise by an unpaid seller of his right of lien or stoppage in transit. No, this is what I am trying. This is what it is telling. What do you mean by rescinded? What do you mean by rescinded? We have already understood. Rescind का मतलब क्या होता है?
Ma'am, to withdraw after the contract is formed.
Hmm. So this means that even if the person has not paid the price and the unpaid seller has no has exercised his right of lien or stoppage in transit, that doesn't mean the contract of sale is rescinded. It is still there. Okay, and the buyer can receive the good back on payment of price. This is what it is saying. But if the buyer has not paid the price, then he will the unpaid seller continue his right of lien or stoppage in transit, but the contract of sale is still there, where the goods are of perishable nature. Okay, so this is about your right of resale, where the goods are of perishable nature, or where the unpaid seller who has exercised his right of lien or stoppage in transit. Okay, so first point is your right of resale is there when where the goods are of perishable nature. So in case of perishable nature, uh, the uh, the contract of seller contract of sale के केस में ऐसा नहीं है कि he will able to exercise right of lien or right of stoppage in transit, because it is perishable nature. So the seller has right to resell without intimating or without giving any notice to the buyer. Okay, but where the unpaid seller who has exercised his right of lien or stoppage in transit gives notice to the buyer of his intention to resell, the unpaid seller may, if the buyer does not within a reasonable time pay or tender the price, resell the goods within a reasonable time and recover from the original buyer damages for any loss occasioned by his breach of contract, but the buyer shall not be entitled to any profit which may occur on the resale. Okay, so what do you mean by here damages for any loss occasioned by his breach of contract? So what kind of what amount of damages seller can claim? We have already understood the liquidated damages. Now try to apply that and tell me what would be the damages amount the seller can claim from the buyer. And please keep it note that when he will give the notice to the buyer, then only this right will come. Okay, claiming of damages and holding the profit amount. So if he has not given a notice to the buyer that he intend to resell, then then the seller loses the right to recover from the original buyer damages for any loss, or can if there is no loss, then what will be the case? There will be a profit. Either there will be loss, there will be a profit, or at same par. same price he has recovered. I am not discussing upon that. So if there is a profit, then that profit amount uh, the seller will retain. Okay, this is what it is saying. I want to understand what will be the damages amount, how that will be calculated. Tell me what is ordinary damages. Don't tell me that you don't remember ordinary damages. Either I am not teaching well or you are not revising. I don't understand. You need to tell me ordinary damages का मतलब क्या होता है.
मैम डैमेजेस जो नेचुरली कॉन्ट्रैक्ट के ब्रीच पे आते हैं, मतलब इट्स रीजनेबली फोर्सिएबल दैट दिस मच अमाउंट इज गोइंग टू अक्यूमुलेट एज डैमेजेस.
करेक्ट अनन्या, करेक्ट, वेरी वेरी करेक्ट. सो बेसिकली अगर मान लीजिए कि आपने 100 रुपीज में खरीद 100 रुपीज में उसका सेल प्राइस था एंड उस टाइम पे सिंस उसने प्राइस पेमेंट नहीं किया एंड ही हैज टू सेल दैट एट 80 रुपीज, दैट मीन्स 20 रुपीज का उसको लॉस हुआ. That is an ordinary damages, right? This is one example we have discussed. So that is the damages amount he can recover it from the buyer. And if he has sold it in suppose 110 rupees, then that 10 rupees profit the seller will recover, will retain. But that is only possible when the seller has given a notice to the buyer of his intention to resell. Okay. And however, this notice is not required to be given in case of perishable nature of good. Third is your if okay. So obviously if the notice has not been given, so it means that buyer can even resell that goods without giving a notice. But if he is reselling that goods without giving notice, that sorry, seller can resell that goods without giving notice to the buyer. But if the seller is reselling that good without giving notice, then this he will lose this two right. That is the only thing what law is saying. Okay. Now third point is your where an unpaid seller who has exercised his right of lien or stoppage in transit resells the good, the buyer acquires a good title thereto as against the original buyer, notwithstanding that no notice of the resale has been given to the original buyer. Right? Without notice also, seller can resell that. But if he resell, then this two right he loses, and the next buyer will acquire the good title over it. Where the seller expressly reserve a right of resale in case the buyer should make default, and on the buyer making default resells the good, the original contract of sale is thereby rescinded, but without prejudice to any claim which the seller may have for damages. ओके, व्हाट इट इज सेइंग, इट इज दैट कि अगर आपके कॉन्ट्रैक्ट में के टर्म एंड कंडीशन में ही आपका उन्होंने दे बोथ एग्रीड दैट कि सेलर हैज राइट ऑफ रीसेल इफ द प्राइस हैज नॉट बीन पेड, देन इन दैट केस even if the seller is not giving a notice, then also the seller has right to claim damages. Okay, please read it. This is what it is saying. Is it clear? Okay. So, by this discussion, can you help me to understand what is the duration of transit? स्टॉपेज इन ट्रांजिट का ड्यूरेशन तो आप बता ही सकते हैं, अभी वी हैव जस्ट डिस्कस्ड. करेक्ट अनन्या. Correct. Ananya has mentioned duration of transit begins when the seller delivers the good to the courier or belly for transmission to the buyer, ends when the buyer or their agent takes delivery from the courier or belly. Right. When the good is delivered to a courier, and it comes to end when it is delivered to the buyer. Okay, Kishan. Correct. Now we have just seen all these rights are against the good. So what is the what in case of unpaid seller, when the seller position is as an unpaid seller, then he has two right. One is against the good, and another is your against the against the buyer. So we have the all these right which we have discussed: right of lien, right of stoppage in transit, right of resale. These are all right against the good. What all rights are against the buyer? Buyer के against में क्या क्या right हो सकता है? आप ऐसे ही सोचिए क्या हो सकता है. अगर आपको लॉ नहीं मालूम होता तब भी आप सोचिए कि अनपेड सेलर के पास क्या राइट होगा. अगर आपको कोई पेमेंट नहीं देता है आपके किसी सामान के बेचने पे, तो आप उस बायर के अगेंस्ट में आपके क्या क्या राइट होंगे एज एन अनपेड सेलर.
मैम गुड्स को विथहोल्ड रखना, नहीं तो बायर को मतलब ऐसे कंपेल करना, या फिर लीगल रिप्रिकॉशंस के लिए लाइक सूट फाइल करना.
गुड्स के बाद केस में तो हम लोग ऑलरेडी देख लिए ना कि हम लोग अगेंस्ट गुड हम लोग क्या क्या एक्सरसाइज कर सकते हैं. राइट. तो विथ होल्डिंग वाला जो आपने कहा कि विथ होल्डिंग डिलीवरी, कि हाँ मतलब अगर प्रॉपर्टी ट्रांसफर नहीं हुआ है तो हम विथ होल्डिंग डिलीवरी के साथ साथ में राइट ऑफ लियन और ये सारे राइट है वो सब अगेंस्ट द गुड्स हो गया. बट अगेंस्ट द बायर,
मैम सूट फाइल कर सकते हैं क्या?
हाँ सूट ही फाइल करेंगे हम लोग. यस क्वेश्चन, क्लेम द डैमेजेस. सूट फाइल करेंगे प्राइस के लिए कि आप पेमेंट करो, हमें पैसे तो दो, है ना. सो सूट फॉर प्राइस होगा. सूट एज क्वेश्चन मेंशन, सूट फॉर डैमेजेस फॉर नॉन एक्सेप्टेंस ऑफ गुड. देयर माइट बी अ केस ना दैट द बायर इज नॉट एक्सेप्टिंग दैट गुड, डिलीवरी नहीं ले रहा है. राइट. तो उसका उसका भी डैमेजेस आप क्लेम कर सकते हो. फिर आप रेपुडिएशन ऑफ कॉन्ट्रैक्ट बिफोर ड्यू डेट, when you have seen that कि बायर इंसॉल्वेंट हो गया है ना, या फिर बायर जो है पेमेंट नहीं करने वाला प्राइस है, तो एंटिसिपेटरी ब्रीच भी हो सकता है. राइट. सो इन केस ऑफ एंटिसिपेटरी ब्रीच के केस में आप क्या करते हैं? या तो आप अभी मतलब आप रिप्यूडिएट कर देते हैं कॉन्ट्रैक्ट को, या फिर आप वेट करते हैं एक्चुअल ब्रीच का. करेक्ट. फिर आप,
यस मैम.
हाँ, और फिर आप जो है इंटरेस्ट क्लेम कर सकते हो प्राइस का. वो डिपेंड करता है कि टर्म्स हैं आपके कॉन्ट्रैक्ट के इंटरेस्ट क्लेम करने का या नहीं, वो है. सो आप जनरल बैलेंस में आप देखो कि अगर वो पेमेंट प्राइस नहीं पेमेंट कर रहा है या फिर डिलीवरी नहीं ले रहा है और डिलीवरी प्लस प्राइस नहीं पे कर रहा है, तो ये क्या हो रहा है? ब्रीच ऑफ कॉन्ट्रैक्ट ही हो रहा है ना. तो ब्रीच ऑफ कॉन्ट्रैक्ट में आप प्राइस का तो आप क्लेम करोगे ही, साथ में आप डैमेजेस भी आएगा. तो just by applying common no whatever the discussion we had till now, these are the things which we can think of. Now let's see what law says. Suit for price, where under a contract of sale the property in the goods has passed to the buyer and the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract, the seller may sue him for the price of the goods. ओके यहाँ पे आप देखो अकॉर्डिंग टू द टर्म्स ऑफ द कॉन्ट्रैक्ट. ओके. और दूसरी वर्ड है आपका रॉन्गफुली नेग्लेक्ट्स, एक वर्ड है, और एक है आपका रेफ्यूजेस टू पे. सी व्हाट इज हैपनिंग, फर्स्ट है कि मैं पैसा दूंगा ही नहीं, दैट इज रेफ्यूजेस टू पे. व्हाट डू यू मीन बाय रॉन्गफुली रिफ्यूज नेग्लेक्ट्स?
मैम बायर शायद भूल गया कि उसने ये गुड परचेज किया है, एंड ही नेग्लेक्ट्स कि मेरा ये पेमेंट ड्यू था.
हाँ, नॉन डेलिबरेट, राइट। रेफ्यूजेस टू पे में आप देख रहे हो कि डेलिबरेटली वो बोल रहा है कि मैं तो पेमेंट करूंगा ही नहीं। और आप जो है लीगली ही हैज टू मेक द पेमेंट, बट ही नॉन डेलिबरेटली मेड द नॉट मेड द पेमेंट। दिस इज व्हाट यू आर ट्राइंग टू से, राइट। बट नेग्लेक्ट वर्ड क्यों आया? क्योंकि ही हैज अ ड्यूटी टू टेक केयर कि पेमेंट होना चाहिए, राइट। सो दैट्स व्हाई इट इज wrongfully neglects. Okay. And the another word is your according to the terms of the contract. बिकॉज कॉन्ट्रैक्ट ऑफ सेल में हमने देखा कि दो चीज होता है, एक होता है सेल और एक होता है एग्रीमेंट टू सेल। सो एग्रीमेंट टू सेल में आपका ऐसा भी हो सकता है ना कि आप प्राइस पहले पे करने के लिए होगा, मतलब ओनरशिप बाद में। आप ऐसा भी होता है ना कि आप प्राइस पहले पेमेंट करेंगे, डिलीवरी बाद में जाएगा। बट अगर आपने प्राइस नहीं पे किया है तब भी आप सूट फॉर प्राइस आएगा। Even if the property has not been, there might be two scenario where the property has been transferred, another is your property has not been transferred. So if the property has been transferred and the possession is with you, and you have not and the buyer has not made the payment, then suit for price. When the property has not been transferred but the buyer has given no a deadline that this at this moment, by this time I will make the payment, but he has not made the payment, that time also it will come as suit for price. Okay. The seller may sue him for the price of the goods. Second, where under a contract of sale, the price is payable on a day certain, irrespective of delivery, and the buyer wrongfully neglects or refuses to pay such price, the seller may sue him for the price, although the property in the good has not passed and the goods have not been appropriated to the contract. So this I have just discussed with you, right? But now what is this? The goods have not been appropriated to the contract. हम लोगों ने एसर्टेन गुड अनएसर्टेन गुड पढ़ा था। आप उस
Yes,
कॉन्सेप्ट का,
ma'am.
हाँ, उस कॉन्सेप्ट को थोड़ा अप्लाई करके सोचिए क्या बोलना चाह रहा है लॉ। We have discussed now that there is a 10 kg of rice, wherein the person has asked for 1 kg of rice. Now that at that moment what uh, it is not ascertained until he will no separate 1 kg from that 10 kg. So when it is appropriated as per the contract, so goods have not been appropriated to the contract. So what it is saying that ki if the buyer has no made up according to the terms of the condition terms of the contract, he has to make the payment of price before that good the property in the good has been passed, or before the goods has appropriated to the contract. That is also possible. So if that terms is there, that in that scenario also the seller can sue him for the price. I hope it is clear. Okay. Section 56, damages for non-acceptance. Where the buyer wrongfully neglects or refuses to accept and pay for the goods, the seller may sue him for damages for non-acceptance. So he has two rights now. When he is not no, accepting the goods, in that case, he can claim damages as well as your price. Okay. Damages for non-delivery. Where the seller wrongfully neglects or refuses to deliver the goods to the buyer, where the seller wrongfully neglects or refuses to deliver the goods to the buyer may sue the seller for damages for non-delivery. It is the opposite right, where the seller is neglecting wrongfully or refusing to deliver. In that case, buyer can sue him for the damages for non-delivery. Okay, specific performance. Subject to the provision of Chapter 2 of the Specific Relief Act 1877, in any suit for breach of contract to deliver specific or ascertained goods, C. Specific or ascertained good. So by this you have an understanding that specific performance is only possible in case of specific or ascertained good. Okay, not in other type of good like your unascertained good or future goods. If it things fit on the application of the plaintiff by its decree direct that the contract shall be performed specifically without giving the defendant the option of retaining the goods on payment of damages. Okay, the decree may be unconditional or upon such terms and condition as to damages, payment of the price or otherwise, the contract may deem just and the application of the plaintiff may be made at any time before the decree. Okay, it is clear, I think. When he has no, he has specified that he wants that good. That in that case, the specific performance, he can the seller, sorry, the buyer can even go for the specific performance of that remedy for breach of warranty. Okay, this I think this 2 3 points you can even read it by yourself. These are also very simple, and if you have any kind of queries with regard to this remedy for breach of warranty, repudiation of contract before due date, this is about anticipatory, where either party to a contract of sale repudiate the contract before the date of delivery, the other may either treat the contract as subsisting and wait till the date of delivery, right? This is anticipatory breach. He may treat the contract as rescinded and sue for damages for the breach. This we have already learned. Interest by way of damages and special damages. So this is according to, see, if suppose if the seller and buyer have already, in the terms of contract it is mentioned that this will be the interest amount, then in that case the interest will be calculated. But if it is not, then and the buyer has not made the payment to the seller, and seller has notified that he will claim for interest, at that time also the interest will be calculated after the date of not after that after when the seller has notified it to the buyer. Okay, or the other route is your through a court. So this you go through it, see if any other thing we are missing. Now, good, I would like to discuss. Okay, so effects of the contract, transfer of property is between seller and buyer. So we have now completed our unpaid seller topic. Okay, this also you please go through. This is about your transfer of property, transfer of general property it is talking about. Okay, goods must be ascertained. So in order to transfer the property, goods must be ascertained. Ascertained, we have already understood the definition. Property passes when intended to pass. So when the property will transfer, when uh, the seller when through the, if अगर आप देखोगे ना, when it is intended to pass, that time the property will pass. It's not necessary that की पोजीशन है बायर के पास तो प्रॉपर्टी पास हो गया है. We have to see that ki what through we have to see through the terms of contract, through the conduct of the parties or through the circumstances of the case कि intention कब है property transfer करने का. Okay, and your section 20 to 24 also decide how unless a different intention appears, the rules contained in section 20 to 24 are the rule ascertaining the intention. So these are the other rules which decides when the property is going to be transferred, like specific goods in a deliverable state. So what is deliverable state, we have already understood. So if the specific goods is in a deliverable state and there is unconditional contract for the sale of specific good in a deliverable state, the property in the good passes to the buyer when the contract is made. So at the time the contract is made, at that time itself your property will passes. Immaterial whether the time of the payment of whether the time of payment of the price or the time of delivery is postponed or both is postponed. Okay, specific good to be put into deliverable state. So if suppose there is a chair and some wheels has to be fixed, so the buyer want that wheels to be there in the chair. So if that wheels is not fixed, it is not in a deliverable state. Okay, suppose if you have already fixed that wheels to that chair, but that is not in the notice of the buyer, at that time also the goods the property has not passed. So it has to be both thing. One is your deliverable state plus your and the buyer has notice thereof. Okay, when both of the thing is there, then the property will pass. Specific good in a deliverable state when the seller has to do anything there to in order to ascertain the price, and that has to be in notice of the buyer. So anything there to in order to ascertain the price. So the rice thing, if suppose no from 10 kg 1 kg rice has been measured, and so that ascertainment of price is possible, or any other thing has to be done to ascertain the price, and it has to be in the notice of the buyer. When all this criteria is fulfilled, then the property will be passed. Okay, sale of unascertained goods and appropriation, this I would like to discuss. Where there is a contract for the sale of unascertained or future good by description, and goods of that description and in a deliverable state are unconditionally appropriated to the contract, either by the seller with the assent of the buyer, or by the buyer with the assent of the seller, the property in the goods thereupon passes to the buyer. Such assent may be expressed and may be given either before or after the appropriation is made. Okay, so suppose in case the goods is in unascertained, matlab suppose uh, if you have not separated say in the rice example, it is not ascertained, like 1 kg has not been measured, and the seller has sold the entire 10 kg to say Mr. C instead of you, because you are the buyer. And before no in that scenario and you have no later on after selling it to C, you have given assent to that sale. At that time also it will consider at fine. This is what it is saying, that see, where there is a contract for the sale of unascertained or future good by description, uh, by description also we have discussed. So, like you have given a description that this type of good you required, and that seller has prepared, seller has made that on certain particular date he will make that good. But before the manufacturing itself, or before it is delivered to the buyer, if seller has no uh, seller himself has sold it to somebody else, and you have given an assent, or you have sold it to somebody else, in both case uh, the property has been passed, because because that time you are recovering that amount. I hope it is clear. Are you getting it, or you're get, suppose Ananya, suppose if I say that you have given me an order of 100 kg of rice, okay, to be produced, and before I produce that 100 kg, you have sold it to Kishan 90 kg, and and you have informed me that now it is not required to be delivered to you, instead it is delivered to Kishan. That is also possible. But the position, but that property has been passed to you, and now you just transferring that good to Kishan, delivering that good to Kishan, right? Or either I have myself transferred, I myself have sold it to somebody else, and I have obtained assent from you. Okay, any query? See, the property in the goods thereupon passes to the buyer, because it is done with the assent. The buyer has given that no permission. Whether that permission is recovered before the act or after the act, that is irrelevant. Okay, any query? We have completed our sales of good act. Rest of the part, just read it, and in case if you have a query, we can discuss it on those topics. The major portion, as per me, I have covered it, and the rest of the topics I think uh, is self-explanatory, and if any kind of query it is there, then we can discuss also, because these are all delivery types of delivery also we have discussed. So no, just apply those understanding and have a reading. And then we can in case of query we can further discuss, if majority of you wanted me to no take another session for that. Okay, shall we end our class? Okay, good night. Thank you all.